Hello everyone, Mr. Lipchick here, and our topic today is going to be civil law. There are different types of civil law. Civil law is defined as disputes between two or more individuals or between individuals and the government. One party has suffered an injury at the hands of another or is seeking to prevent a harmful action from taking place. 90% of civil law cases take place in state courts. There are four important types of civil cases: contracts, property, family law, and tort law. Tort law is the law involving civil wrongs causing personal injury to property. Excuse me, personal injury or injury to property. Contracts. A contract is a set of voluntary promises enforceable by law between parties who agree to do or not to do something. An express contract is one in which terms are specifically stated by third parties, usually in writing. Or by the parties, not third parties, beg your pardon. An implied contract is one in which terms are inferred from the actions of people involved and the circumstances. In order to be valid, a contract must have the following criteria. Must be between individuals who are mentally competent. You cannot be mentally ill, severely mentally ill, or have some other mental deficit. It must involve persons of legal adult age in most cases. To the right, you'll see a picture of Led Zeppelin. In the 1970s, the National Record Club sold albums to children via the mail. These contracts were invalid, and the children got to keep the albums because the parents did not give their consent. The contract must not involve doing or selling anything illegal. The contract cannot maintain something illegal inside of it. And it must include an offer, acceptance, and in most cases, a consideration. An offer is a promise that something will or will not happen. An example, a remodeler offers to fix your kitchen for $1,000. Acceptance is agreement, orally or in writing, to accept the offer. Example, you accept the remodeler's offer to fix your kitchen for $1,000. And consideration is giving, exchanging, performing, or promising each other something of value. And in our example, the $1,000 in return for remodeling the kitchen is the consideration. There's also property law. Real property is defined as land and whatever is attached to or growing on it, such as houses or trees. Personal property is movable things like clothes and jewelry, as well as intangible items such as stocks, bonds, and copyrights. Property law involves legal disputes arising over using, owning, buying, and selling property. State and federal laws exist to protect property and prevent discrimination in buying and selling. Family law. Family law deals with the relationships among family members, including marriage, divorce, parent-child relationships, and child custody issues. Family law in the U.S. developed outside of the church. States developed their own family laws over time. Marriage became a civil contract between a man and a woman. Divorce legally ends a marriage and leaves both parties free to remarry. Torts, or civil wrongs. A tort is any wrongful act, other than a breach of contract, for which the injured party has the right to sue for damages in a civil court. There are two major categories of torts. One, an intentional tort, a deliberate act that results in harm to a person or property. And two, negligence, a tort involving careless or reckless behavior. To the right, you see the famous example of the surgeon who left his forceps inside a patient's chest, opening him up for a negligence tort. Persons filing tort cases can be awarded money to compensate them, and sometimes punitive damages to punish the party causing the injury. There are steps in a civil case. Civil cases are called lawsuits. A plaintiff is the person who brings charges in a lawsuit, also referred to as a complaint. And the person is sometimes called a complainant. A defendant is the person against whom the lawsuit is filed. The plaintiff usually seeks monetary damages, but sometimes seeks an injunction. An injunction is a court order forbidding a defendant from taking or continuing a certain action. If the court decides in favor of the defendant, the plaintiff must pay all court costs. If the defendant loses, they are usually required to pay court costs as well. Hiring a lawyer is usually the first step in starting a lawsuit. Some lawyers may work on a contingency fee, which is usually a percentage of the money won in the lawsuit. No fee is paid if the lawyer loses the case, but the plaintiff pays the court costs and other expenses. Lawyers will usually not work in this way unless the case is very clear and winnable. Usually, lawyers will charge an hourly rate of $200 to $300 per hour. The next step is to file a complaint, a legal document, with the court that has jurisdiction over the matter. The complaint tells the defendant what is at issue so that a defense can be mounted. The defendant receives a summons or official notice of the lawsuit that includes the date, time, and place of the initial court appearance. The defendant may file a motion to dismiss, asking the court to end the suit. The defendant must file an answer or formal response to the complaint within a certain time frame. If the defendant fails to respond, the plaintiff wins the case by default. The defendant may file a counterclaim asserting that the plaintiff also did something wrong. The next step is pretrial discovery, when both sides prepare for a trial by checking facts and gathering evidence. It is a very expensive and time-consuming step. The lawsuit may be settled before trial as expenses mount or parties see weaknesses in their cases. Sometimes the parties submit their case to mediation or binding arbitration instead of going through the court system. If the parties fail to settle their case, they will go to trial. The trial may be heard by a judge or a jury. The plaintiff is heard first, followed by the defendant. Both sides summarize their cases, and the judge or jury renders a verdict. When a plaintiff wins a case, the court awards damages, injunctive relief, or both. Judges can modify jury awards if they feel they are not in line with the injury. Plaintiffs or defendants can appeal the case, and it can go on for years. Sometimes the losing side refuses to pay, causing the plaintiff to seek a court order enforcing payment. A defendant's property may be seized or money withheld from their paychecks in that case. Small claims court. Small claim courts are courts created by most states in order to avoid the time, expense, and high costs of going to trial. Here, they hear civil cases involving collection of small debts, property damage, landlord-tenant disputes, and small business problems. Usually the cases involve maximum claims ranging from $1,000 to $5,000. A small filing fee is charged and no lawyer is required. The judge listens to the parties and issues a decision. To the right you'll see Judge Judy, and you've probably seen her on TV, and she in her show is handling small claims. If the defendant loses and refuses to pay, the plaintiff files forms with the court and seeks to have the police enforce payment. That concludes our discussion of civil law. Thank you for attending, and I look forward to seeing you in the live lesson. Have a great day.